You are listening to PR Radio Station of America.
The sun was setting behind downtown Los Angeles as Governor Gavin Newsom walked up to a podium outside a civic building, flanked by state lawmakers, school leaders, and immigrant advocates holding banners. Television cameras clicked in rapid succession, capturing a scene that felt both celebratory and defiant. Crowds chanted in Spanish and English, holding homemade signs that read, "No more masks," and "Transparency is safety." For many families in attendance, this was not an abstract political gesture. It was personal. They had watched friends and relatives taken away by officers in face coverings, bundled into unmarked vans with no clear identification. Newsom lifted the pen and signed the bill into law with slow deliberation. He then looked directly at the crowd and declared that California would not tolerate faceless arrests. He reminded everyone that 27% of residents in the state were foreign-born, and their rights mattered just as much as anyone else's. He painted vivid images of what the raids in Los Angeles had looked like: masked figures moving through neighborhoods, children crying as parents were detained, and community members whispering that they felt as if they were living in a dystopian movie. "Immigrants have rights, and we have the right to stand up," he said firmly. The new law was sweeping. It barred most law enforcement officers, including federal immigration agents, from covering their faces during official duties. Ski masks, neck gaiters, and other face coverings were now banned in routine operations. Exceptions remained for undercover work, tactical protective gear, and medical masks. But the central message was unmistakable. When agents engage with the public, they must be identifiable. Supporters believed this rule would rebuild trust, reduce impersonations of officers by criminals, and prevent abuses that thrive in anonymity. Applause roared from the crowd. Parents cried and hugged one another, convinced that this law would mean their children would no longer fear men in masks breaking into their homes. Community leaders took the microphone after Newsom and framed the moment as historic. One activist said, "For years we have lived in fear of unmarked cars and masked strangers who take our neighbors away. Today California says no more." Teachers in attendance waved signs for the companion bill that protects schools and health centers from immigration agents without a warrant. Yet beneath the celebration, uncertainty hung heavy. Reporters peppered the governor with questions. How will this law be enforced if federal agents refuse to comply? What penalties exist for violations? Could this lead to direct confrontations between state and federal officers on California streets? The crowd quieted as Newsom acknowledged that the road ahead would be difficult. He said clearly that this was about principle as much as enforcement. "We choose transparency over fear," he declared. The applause rose again, but so did the sense that California had just lit a fuse in a national confrontation. Barely an hour after the ink dried on the governor's desk, Washington struck back. On social media, Bill Asaley, acting federal attorney for Southern California, declared that California had no authority over national operations. He instructed federal agencies to ignore the law, assuring officers that nothing had changed. "Our agents will continue to protect their identities," he wrote. The message was short but sharp, designed to reassure federal teams and to signal to Sacramento that the confrontation had begun. Soon after, a statement landed from the Department of Homeland Security. Officials argued that the law endangered officers and their families. They described agents being followed home, their children's schools targeted online, and their names posted by activist groups. To them, masks were not about intimidation but survival. Tricia McLaughlin, a Homeland Security spokesperson, called the California law a flagrant attempt to endanger our officers. She painted a picture of masked agents pelted with Molotov cocktails and bricks while being told by politicians to take off their protection. The words inflamed the national conversation, drawing battle lines between safety and transparency. Newsom and his allies quickly countered. They dismissed the federal narrative as fear-mongering without evidence. "There is no data that shows assaults on officers are rising because of identification," Newsom said at a follow-up press briefing. Supporters of the law emphasized that visible identification is essential in a democracy. Without badge numbers and names, they argued, residents cannot distinguish legitimate officers from criminals pretending to be them. Constitutional experts were invited onto local television panels to explain that while federal supremacy is clear, states can still regulate conditions of public safety within their borders. The debate grew louder, layered with legal jargon and emotional testimonies. Meanwhile, the tension played out on the ground. In Los Angeles and Oakland, protesters marched outside immigration offices, chanting "Show your face" and "No more masks." Counter-protesters gathered nearby, waving American flags and signs that read "Protect our officers." At one demonstration in downtown Los Angeles, police formed barricades to keep the groups apart. Journalists reported heated shouting matches where one side insisted that masks are tools of fear, while the other argued they are shields for families under threat. The divide was no longer confined to lawmakers or officials. It was now visible in neighborhoods and city squares. Cable networks split the screen. On one side, footage of masked officers in black tactical gear entering an apartment complex. On the other, activists describing children crying as masked figures carried their parents away. Legal analysts filled the airwaves with arguments about supremacy clauses, state rights, and federal powers. The public was left confused and divided. To some, California was standing up for democracy. To others, the governor was recklessly endangering the lives of men and women on the front lines. The clash had quickly grown beyond California's borders. Other states began drafting similar proposals, and the nation braced for a fight that was no longer about masks alone, but about who holds the power to define the rules of justice. In Boyle Heights, a grandmother described how her grandson wakes up screaming when he hears sirens. She said masked agents had come to their apartment complex before dawn, taking two neighbors without showing names or badges. To her, the new law felt like a shield, a promise that families would no longer be dragged into the unknown by faceless men. Across Los Angeles, similar stories echoed. Children left crying at bus stops, parents afraid to walk to work, and households where blinds stayed shut all day. The ban on masks gave communities hope, even if enforcement remained uncertain. In Southgate, a high school teacher told reporters that her students asked daily whether officers can still storm their classrooms. Fear had reached such a level that some parents hesitated to drop their children off at school. To address those worries, Newsom signed a companion law. Immigration agents may not enter schools or healthcare facilities without a valid warrant or judicial order. Schools must also notify parents and staff when agents are present. Advocates called it the Safe Haven Schools Act. The law was framed as a guarantee that learning spaces remain safe from surprise raids. Hospitals and clinics also became part of the conversation. Doctors recalled patients who skipped medical appointments out of fear that masked agents might be waiting. Nurses told of children needing checkups who never showed up. Under the new law, clinics and hospitals now had clear protections. Agents must present warrants, and administrators are required to inform families when federal officers are on site. Healthcare workers applauded, saying it will help restore trust in medical spaces where public health should be the only concern. Local police unions, however, expressed concern. Officers working in gang-infested neighborhoods said removing facial coverings could expose them to retaliation. Some recalled incidents where their families were followed home after arrests. They argued that the law might compromise safety in ways lawmakers had not considered. Union leaders called for amendments, asking for broader exceptions for tactical operations. Civil rights advocates responded firmly. Undercover work and tactical gear already had exemptions. The debate revealed deep divisions, not just between state and federal officials, but within law enforcement itself. By midweek, California felt like two different places. In immigrant neighborhoods, rallies framed the law as a victory for dignity and visibility. Parents said their children finally slept without fear. Meanwhile, in law enforcement briefings, officers whispered about being left vulnerable, convinced that Sacramento was ignoring the risks they faced on the streets. The tension was palpable. On one side was a demand for transparency and trust. On the other, a plea for protection and survival. Both realities were true, and both collided daily in the streets, schools, and clinics of California. Within days of the bill's signing, lawsuits were filed. A coalition of administration-aligned attorneys argued that California had no authority to regulate the attire of federal agents. They claimed the statute violated the supremacy clause of the Constitution, which gives federal law primacy over state law. California lawyers countered immediately. They argued that the measure does not interfere with national security duties, but instead enforces a basic principle of public safety. Officers must be identifiable when engaging directly with civilians. Courtrooms buzzed with filings, and media outlets broadcast the legal battle as if it were a heavyweight prize fight. Constitutional experts filled editorial pages and television panels. Erwin Chemerinsky, dean of Berkeley Law, defended California's approach with a simple comparison. Federal employees must still stop at red lights while driving in the state. If traffic rules apply, why not visibility rules during public interactions? Opponents countered with equal force, saying red lights are universal safety measures, while mask bans threaten federal agents' ability to operate in hostile environments. Scholars agreed on one thing. This was a test case that would likely rise to higher courts. The legal battle grew more complex because the Supreme Court had recently permitted the administration to resume sweeping immigration raids in Los Angeles. That ruling set the stage for California's law to collide head-on with federal power. Judges asked pointed questions in preliminary hearings. Could a state impose identification requirements without obstructing federal missions? Could California punish local officers who participate in raids alongside masked federal agents? The answers remain murky, but every argument hinted at a showdown that might reshape the balance of power between states and Washington. On the ground, police chiefs scrambled to interpret the law. Some issued memos requiring local officers to keep badge numbers visible during all operations. Others quietly admitted they would look the other way when working with federal partners. Community advocates demanded strict enforcement and penalties, while union leaders warned of confusion in split-second moments during raids. The result was a patchwork of compliance. In some counties, officers removed masks. In others, little changed. Californians watching from the sidelines wondered if the law had teeth or if it was mostly symbolic. As hearings dragged on, the bigger question loomed. Is transparency a state right or a federal threat? California positioned itself as the defender of democracy, saying mass arrests erode trust and mimic authoritarian regimes. Federal officials positioned themselves as protectors of order, arguing that anonymity keeps officers alive in an age of online doxing and targeted violence. Each side spoke the language of safety, yet they defined safety in opposite ways. By the end of the first month, one thing was clear. This was not just a fight about masks. It was a constitutional struggle over who decides the rules of justice in America's largest state. California's law did not stay isolated for long. Lawmakers in Tennessee, Michigan, Illinois, New York, Massachusetts, and Pennsylvania quickly introduced similar bills. Some mirrored the mask restrictions word for word, while others focused more narrowly on requiring badge numbers during arrests. Advocates framed these proposals as a wave of accountability, insisting that transparency must be a standard, not a luxury. Opponents warned that states were overstepping into federal turf, setting up a patchwork of laws that would confuse officers and weaken enforcement nationwide. In immigrant-heavy neighborhoods across Los Angeles, Oakland, and Fresno, the mood shifted. Parents said their children were less afraid walking to school. Churches hosted Know Your Rights, events that now included leaflets explaining the mask ban. Community leaders told families to record badge numbers, reminding them that visible identification was no longer optional but required by law. For the first time in years, many residents said they felt they had leverage in encounters with law enforcement. They knew the fight was far from over, but the symbolism of seeing faces instead of blank masks carried real weight. Meanwhile, police associations and federal unions sounded alarms. They claimed the new laws made officers targets for revenge. Some shared stories of colleagues whose personal information had been posted online after raids. Others said that family members had been threatened at schools or workplaces. National law enforcement groups began lobbying Congress to pass a bill protecting the right of federal agents to conceal their identities during operations. What started as a California policy now sparked a debate in Washington about national standards, with lawmakers split along partisan lines. Legal scholars described California as the laboratory of democracy. If the state's law survived court challenges, it could set precedent for the entire nation. If it fell, it would reinforce federal supremacy and limit states' ability to regulate how officers interact with the public. Either way, the stakes were immense. Residents across the country watched the court cases closely, knowing that their own states might soon adopt or reject similar measures. California had forced the country to confront the uncomfortable balance between transparency and security. By the end of the first year, the law had become more than a rule about masks. It was a symbol of two competing visions of power. One vision argued that democracy requires visibility, that a badge and a face are the minimum proof of legitimacy. The other vision argued that safety demands concealment, that officers deserve protection in an era of online threats and violent protests. California stood at the center of this divide, celebrated as a champion of rights by some, denounced as reckless by others. The ripple effect was undeniable. The debate had spread beyond California and had become a national conversation about what justice should look like in the streets of America's largest cities. This is the end of that story. Now tell me in the comments, what's your story? I'll read out the most interesting ones in the next video. Do not forget to hit a like button and subscribe. See you.